Hello everyone and welcome to the British Plastic Federation Lunch and Learn webinar. My name is Paul Baxter. I'm the Events Executive here at the BPF and I will be your host for this webinar. The topic for today's webinar is Brexit, the legal implications, and we at the BPF are delighted to welcome BPF member company Squire Patton Boggs to present on this important subject. We have several speakers from Squire Patton Boggs who will be speaking on different aspects of the impact of Brexit over the next hour, and we'll start with an introduction from Paul Anderson. At this point, I would like to say that if you do have any questions, please fill in on the questions tab, and there will be a chance at the end of the webinar for me to ask your questions to the team from Squire Patton Boggs. So without further ado, I will now pass control of the webinar across to Paul Anderson.
Thank you, Paul. Good afternoon, everyone, and welcome to the Squire Patton Boggs webinar. Next slide, please. No, we don't need that one for very long. There I am. So next slide again. Thank you. We're going to talk today about a number of Brexit-related issues. We're going to focus on legal issues. Perhaps not surprisingly, we may find ourselves crossing into some political commentary. We don't hold a political position ourselves, as it were, but it is worth making some points around Brexit, how it would work, and factoring in the current political situation because it's very relevant to where we may end up. The subject itself has required us to spend a lot of time talking to clients over the last few weeks. We are seeing both nationally across our European practices and offices and internationally, particularly with our US colleagues, a great interest in what will happen. At this point, it's one of those perhaps unusual and slightly uncomfortable positions for lawyers where we aren't able to say an awful lot about precisely what will happen because we do not yet know. And you will see some of that coming across in the presentations today, for which we make no apology. You will see some evidence of areas where we do have particular concerns simply because of the nature of the EU at present, and if you're not in it, then you're outside it. So you do know certain things. So to summarize the agenda for today, we're going to give you an overview of the current position in terms of the UK and how it might withdraw from the EU. I will provide that overview. I'm going to then introduce to my colleague Aline Doussin, who's going to talk about trade-related issues. Then to Supinder Sayan, who's going to talk about business immigration issues, which is certainly an area where we have had a lot of inquiries. And Supinder's then going to hand over to me, and I'm going to talk a little bit about the financial services and contracts related issues that arise. And last but not least, I'm going to hand over to Carl Roessler, who's going to talk about intellectual property issues. And I'll ask each of the speakers to introduce themselves and the practices that they cover as they join. So, next slide, please. This slide just summarizes where we Squire Patton Boggs are at the moment. I think the principal bits of work that we have found ourselves doing at this stage have been talking about potential impacts for EU employees. So there's been quite a bit of work and discussion relating to EU nationals in the UK. We've also found ourselves, particularly in the financial services sector, talking about the way in which financial services businesses carry on their activities cross-border and through branches in other jurisdictions. That being a particular concern of UK firms who use so-called EU passports to establish or to provide services cross-border. So they've been the sort of material focus so far, but we are finding ourselves supporting a wide variety of firms and industry sectors across Brexit at this stage, including the public policy side. So we are gathering together some instructions from clients who are likely to pool before instructing us to seek to influence particular outcomes, and passporting in financial services is one of those areas. Next slide, please. So the position today, easy comment to make, we're still in a period of uncertainty. We do not yet know when Theresa May, the new Prime Minister, will trigger the Article 50 mechanism. The feedback, depending on which newspaper you read this morning, the feedback from Germany was either Theresa May told Angela Merkel that we would do it when we felt like doing it and it wouldn't be until the start of next year, or if you read a different newspaper, Angela Merkel extended I suppose an olive branch to say that, you know, we will recognise and work with you in accordance with an appropriate timescale. So there is and remains uncertainty as to when that will happen, but the sort of best initial guess is early 2017. Leave campaigners, of course, have made it clear that they believe there's no rush for the UK to trigger Article 50. I suppose the counter to that is that we now have a new government which has very clearly said Brexit means Brexit. This does not seem to be a political negotiating point. The government has established itself, and you've seen that by the cabinet appointments made, that Brexit does seem to mean Brexit. The EU institutions and member states offered a mixed response, but seem to be in favour of starting the process. This is an interesting sort of EU political point, and my Brussels colleagues who enjoy all the political machinations of these things would say that the EU institutions, you know, that they are a group of people who sort of transcend national boundaries, and their clear position is that the UK needs to get on with it. You've heard that from Juncker, and we've heard messages from the EU Trade Commissioner who said the UK needs to get on with it. There's a very clear 2-year time frame. After that, we'll start negotiating about what comes next. Member states and the leaders, so the sovereign states themselves, seem to be slightly different. So you get the sort of olive branch that, depending on which newspaper you read, seems to have been extended by Angela Merkel yesterday. You get other countries that are very closely interested, like Ireland, who, you know, want to make sure that things work out smoothly, seemingly offering a slightly different response. But if Brexit means Brexit, Article 50 needs to be served at some point. Next slide, please. So what is Article 50? Well, I suppose there are two material parts to it. The first part of Article 50, and this is in the Lisbon Treaty, so this appeared, I think you would describe it as an unenthusiastic attempt by Europe to offer up an exit mechanism. So certainly those EU institutions that I mentioned on the last slide were never terribly keen for anybody to ever leave. And the extent of work and level of drafting in Article 50 probably reflects that. So Article 51 says that any exit needs to be in accordance with the constitutional requirements of the exiting member state. The UK has the European Communities Act. And the Article 52 and 3 set out those things which are in the bullet points there. So the service of the Article 50 notice is followed by a process of negotiation of the withdrawal agreement. Now, important note there, withdrawal agreement, not necessarily the whole of the future relationship, and it would be somewhat surprising if it was capable of pulling in everything else that would follow. So it has that wording taking into account for future relationships, so there's a kind of forward-looking plan, but most certainly not a new deal within the 2-year period. So best guess, you would get to the end of the 2 years, you would have a negotiated and agreed withdrawal agreement, but you would not have a final definition of what the future relationship between the UK and Europe looked like. Practical points, the second smaller bullet point there, details of future relationship, need for future relationship agreements, parallel or separate negotiation. Again, there's a point where there's a divergence, I suspect, between member states and the EU institutions. So the music from the EU institutions is, oh, you have your 2 years, you exit, then you start negotiating your new deal. I very strongly suspect that there's a difference there between certainly the UK position, but also probably the other member states. So it may well be possible to start parallel discussions about the future relationship at the same time as talking about withdrawal. The withdrawal agreement requires a majority decision of the European Council and adoption by qualified majority with consent of the European Parliament. Nothing particularly surprising in there, and as things currently stand, one would expect those to go through, assuming it is negotiated to an acceptable level. If not, the 2 years expires and we just leave. It is possible for an extension of that 2-year period, but it does require unanimous consent of member states. So that's the process. That's what it looks like. It is obviously untested, unknown. The timescales are unpredictable. Apart from there is that 2-year cut-off, and unless there's a very clear direction which it made sense for an extension, then it's quite difficult to pin anyone's hopes on getting an extension from all member states, I think. So at that point, I will hand over to Aline Dussin.
Thank you, Paul. Thank you. And I think we can already go to the next slide. Thank you very much. So first of all, just to perhaps introduce the actual subject and topic of my presentation, I wanted today to talk to you to focus on trade issues and what the agreements or the arrangements that are currently envisaged could impact you as importers or exporters or manufacturers located in the UK, and I'm sure trading with the EU, but also outside of the EU. I'm a trade practitioner, and in fact I come from both a legal and a policy background. I used to work at the WTO and in the Commission, start of my career, and now I work with companies and clients like you and advise them on what sort of trade rules they have to comply with when trading externally. Obviously, the trade is a major topic in the whole Brexit discussions, and probably one that is on top of the agenda, not only for the government, but also the lobbyists, the lawyers, and the companies that will be involved in those discussions. And I'm sure the federation that you are a member of will actively monitor what is being negotiated. And why is this? Why is it so important? Because effectively to this day, what the UK trade rules look like are almost completely derived from its membership with the EU. And upon withdrawal, there is a big question mark as to what sort of advantages or rules will continue to apply in your trading relationship, and what are the existing options that the government will be looking at on your behalf with the EU, but also with third countries. And I think we can obviously take a look and envisage the first line, which I'm sure you all know if you've taken a look at trade, EU trade relationships and policy currently. So what is this first slide? Obviously, and perhaps just one step back to come back on what Paul has said with respect to the withdrawal agreements. What is perhaps not essentially being clarified is that Article 50 only deals with exiting the EU and the principles that would apply with the UK withdrawal from its membership. But what Article 50 doesn't look at is how the future trading relationship with the EU will look like. And that's obviously why all the current options that are existing in the EU are currently envisaged. And what are those options? If you look at this slide, you see 4 different options being emerging. And those are the existing ones. Obviously, there are some voices that are currently advocating for the crafting of a bespoke relationship, which does not appear on the slides because obviously it's not in existence as yet. But it's also one of the options. But at the moment, we have 4 different ways. When I say 4 different ways, is when a country is not a member of the EU, you have 4 different models that are currently in existence and that the UK could potentially use as part of its future model of relationship with the European Union. So I'm going to walk through these 4 different options and perhaps highlighting what it would mean for you as traders based in the UK. If we could go to the next slide, please. Thank you. So the 4 options, and I'm sure you've already heard quite a lot about it, so perhaps I will try to highlight on what has not been essentially said on those options. We talked a lot about membership to the customs union. And when we talk about the customs union, in fact, at this stage, we talk about obviously the relationship that the current EU 28 have with Turkey. Turkey is the only non-EU member state that is part of the customs union. And why is this? You will probably remember that Turkey in 1963 applied for membership to the European Union, and it is as part of this application and its accession path to the EU that it is currently, it has this privileged access to EU trade via being a member of the customs union. What does it mean for Turkey? It means that when it trades with the EU, it trades with no tariffs imposed on any of its trades. It means that it does not have to comply with all these customs procedures that you will know about when you trade outside of the EU. So that's obviously a huge advantage for trade EU-Turkey and for Turkish exporters and importers, in fact. There are some disadvantages, obviously, even being a member of the customs union. The first one is all the negotiations that the EU undertake on behalf of the 28 with other trade partners, for instance, the United States. Turkey is not sitting at the negotiating table, but it will have to apply whatever the EU negotiates and agrees with other trading partners as part of its membership to the customs union. Quite a bit of a weird setting, which has in fact has created a number of hurdles with respect to the TTIP, and which has obliged the EU to undertake some sort of bilateral negotiations with Turkey behind the scenes when entering into negotiations with the US. Last but not least, Turkey, even inside the customs union, does not apply freedom of movement of workers, which is obviously a big consideration in those negotiations that will be often between the UK and the EU. Moving on to the second model, what we call the Norway model, but which is in fact a bit misleading because when we talk about the Norway model, we talk about membership to the European Economic Area, which includes not only Norway but also other members such as Liechtenstein and Iceland, but we talk about Norway because it's the biggest. Norway is, as you know, outside of the EU, but does trade with the EU under specific arrangements that have been negotiated under the EEA agreements. And what are those principles? Well, the main ones is obviously huge interest and could be a big benefit for EU exporters and importers if the UK government was to go towards this model, is that there is no tariff on most goods that are trading between the two countries, the bloc and these countries, with exception on some chapters, and the main ones are agriculture and fisheries, and that was obviously the reason why Norway never expressed its interest in joining the EU. It was because it always wanted to exclude its fishery sector from the scope of the trading relationship with the EU. Norway as an EEA members are not party to any EU trade deals that the EU negotiates, so it has to negotiate its own trade deal, which means that if the UK was to become a member of the EEA, it would have this ability to negotiate other trade deals with its main trading partners. But the big downside, obviously, is that it pays quite a large amount of money into the EU budget, and it has to abide by the freedom of movement of workers. So potentially not ideal, considering the way the campaign was conducted, and the fact that obviously migration is a big topic as part of these negotiations, and that the new Prime Minister has made it clear that it will take this into account in whatever model she will choose as part of the negotiations. Moving on to the next slide, if we can. Thank you. I will just touch on this other model that has been discussed quite a lot, i.e. a potential bespoke trade bilateral agreements with the EU that could be envisaged by the UK. This is currently what a number of countries have, but the one that is the most debated on, because it's the most integrated one, is Switzerland. So Switzerland is a bit different than any EEA members, because it's a member of EFTA, but has a separate bilateral agreement, in fact a number of bilateral agreements with the EU. And what do these agreements cover? They cover, well, we are talking about approximately 120 bilateral agreements, so imagine the scale of the number of years that in fact it took to negotiate all these rules. We're looking at a 20-year plus time frame of negotiations, and it is still going on. Perhaps you have seen a number of news items a couple of weeks ago on negotiations, including on free movement between Switzerland and the EU, which Switzerland tries to resist, but not very effective at this stage. So very long negotiations, no access to financial services, which Paul obviously mentioned passporting, which is obviously a huge interest to UK financial services companies. So no access to passporting rights, except in some specific sector like insurance, accept freedom of movement, and is outside of the customs union. So in reality, it's quite a complex relationship, and obviously Switzerland, as part of this trading relationship, does not have any say in shaping any of the rules that ultimately it will have to comply with as part of its trading agreement. Last but not least, we talked a lot about the WTO and whether in any event should none of these options be acceptable for the UK government. The UK would still have the ability and obviously be legally entitled to apply the WTO rules with respect to its trading relationship with the EU. Obviously, you will know that the UK, being a member of the EU, is also a member of the WTO in its own right. So withdrawing from the EU will not impact any of its rights in this regard. So it will obviously still be under the rules that have been negotiated as part of membership to the World Trade Organization. What does it mean? It means that you still have obviously a number of tariffs that are being applied for trading as WTO partners, and those tariffs are negotiated quite at length upon accession to WTO with other members. It actually forms part of quite the most difficult part of WTO negotiations. WTO rules does not include any sort of customs union consideration, which means obviously custom procedures and paperwork when trading between members, and obviously acceptance of the most favored nation rules. Whatever you apply to a WTO member has to be applied to others under a non-discriminatory and transparent manner. So moving on to the next slide, what I wanted to do is perhaps talk to you a bit more in detail in what any of this, any or all of these options mean to you as UK businesses. And a lot of it is still being discussed because, as you will have heard, there is currently an international trade ministry that is being formed with, we are talking about potentially 300 plus trade negotiators that are currently being hired by the UK government, and all those negotiators will have to basically form a sort of a consensus on what the UK government will negotiate. But from a trade perspective, they will have to look, or we would recommend that they look at a number of issues on your behalf. The first one is what will happen with tariffs and quotas and customs duties. Upon withdrawal, the UK will effectively withdraw from the EU customs territory. We consider that the Turkish option is very specific and particular as part of its accession path, so it will no longer apply. Which means that goods imported from the UK into the EU will now be subject to the EU common customs tariffs. A big importance for you, I am sure. Conversely, goods imported into the UK will be made subject to customs duties to be imposed as part of the UK national customs tariff that you will have to negotiate. And on this point, what we recommend, obviously, is that you as federation take a look at what you currently have with other trading partners and ensure that whatever the UK position will be on tariff will also include a consideration on your specific industry. With respect to custom procedures, this is a tricky point because in none of the models that the UK government is taking a look at, none of them includes membership of the customs union. So it's very likely that you will have, when trading with the EU, re-imposition of declaration of the goods that are imported into the EU, filling out a number of custom forms, and you will all know the 50 plus boxes that request a number of information on your products, documentary evidence with respect to proof of origin, customs value declaration, inspection, certification. So what we recommend is at this stage is you take a look at your contracts and you really assess what obligations you have with respect to those customs procedures at this stage. That's on contractual terms. So ensure that if you subcontract any of those procedures to your freight forwarder, what will be the cost of potentially having them doing all of this for you on your behalf upon withdrawal. As well, this will all depend on whatever regulatory conversion, regulatory standards the UK will be negotiating with the EU. But potentially there will be some changes unless it goes for membership to the EEA. Trade remedies, which means that the EU rules will potentially no longer apply to the UK. Which could be an opportunity for UK companies as well to negotiate a specific national trade defense instruments as part of its trading relationship. And export control and sanctions, that's again a huge consideration for exporters because any UK licenses will have to be mutually recognized by the EU, so there will be a number of legislative changes needed, not only in the EU, but obviously in the UK with respect to what goods and products the UK will still want to control outside for trade outside of the zone. So Bona, it's a bit of a mixed bag, I would say, of consideration. Just one takeaway is really we see the trade issues as the top ones, perhaps one of the top ones as part of your negotiations, and trade associations and trade federations are currently obviously crafting position papers ready to go to the government when the negotiations will begin. And we obviously recommend that you start taking a look at what you would want to potentially negotiate, and we are here for you to help if that is of interest.
Thank you, Eileen. Can we have the next slide, please? Next slide, please, Paul. So my name's Sapina. I'm a partner in the business immigration team at Squire Patton Boggs. I specialise in UK inbound immigration, working for a number of corporates. And as part of our practice, we support a number of EU nationals moving into the UK with various applications under the current EU regulations for immigration. And the next slide, please. So Brexit, a significant platform of the Leave campaign, was based on the UK's frustration with immigration. Merkel this morning came out to say Brexit was due to immigration. It was a vote for immigration by the UK people. So it sat very high on the agenda, and the vote, and it took a very emotive vote from the people. So this is something the current and new government will need to address, and will need to be very clear on the point and how they take the UK forward in respect of immigration, but retaining the stance the UK is open for business and the ability to continue to attract the brightest and the best and have a range of labour forces to cover the various roles we have open within the UK. So when the Conservative Lib Dem coalition came into force, the government pledged to bring net migration down to 99,999, so into the tens of thousands from the 300,000-400,000 we're at the moment. That failed year on year. The now PM, Theresa May, took the poison chalice of being Home Secretary and lasted longer than most, with a target that she would never have been able to meet with EU migration. Now she's taken the top spot. It is understood the government are likely to scrap any immigration targets. So what next and what now? The UK is still members of the EU. The single market, freedom of movement still applies. So there should be no, there should be a message of calm that goes down to your workforce in that to continue as normal. And I will discuss on the next slide the various options your EU staff population can take to regularise their stay and put them in the best position for any transitional arrangements. It's still too early to predict the long-term outcome of Brexit. Nobody's come out with any immigration policy. The Leave camp didn't put forward any immigration policies or what May adopted. We now wait for the Brexit ministers, Theresa May, the new Home Secretary, to come out what their post-Brexit immigration policy will be. So as you've heard, we're likely to have quite some time to plan and negotiate the exit from the EU, which is a good thing because immigration is going to be incredibly complex to sort out. So in the short to medium term, we have stability. After that, we do not know what will apply, whether the current points-based system will be adopted or whether we will have a whole new system in place. And just to look at the numbers we're talking about, we have approximately 3 million EEA nationals living and working in the UK, and approximately 2 million Brits living in other EU member states. So we would anticipate that they would be allowed to stay and there would be no mass repatriation policy, even in light of Theresa May and David Davis's comments. We can expect grandfathering immigration regulations to regularise their stay, and a potential cut-off date for any future EU immigration into the UK to protect the borders and not to further increase net migration into the UK. So essentially opening the floodgates before the rules change. And then we'd expect similar provisions for EU member states to apply to Brits living in their countries. But if the UK imposed stricter regulations on EU nationals living in the UK, we can certainly expect those EU member states to apply equally rigorous standards on Brits living in those member states. And we can see some of the rhetoric from France and Germany, once being sort of pro starting negotiations, delaying negotiations, so that would be Germany, and then France who wanting to kick things off as quickly as possible. So we'll see what happens. Next slide, please. So I want to take you through the various options open to EEA nationals currently living in the UK and what we call exercising treaty rights. Now, an EEA national may come to the UK for a period of up to 3 months without exercising one of the following rights. So these are known as qualified persons or those exercising treaty rights. So as a worker, a job seeker, someone who's self-employed, somebody who's self-sufficient, or as a student. If they're not exercising one of those treaty rights beyond the 3-month stay, technically they shouldn't continue their stay in the UK, but that's very, very difficult to police. So we'd anticipate your workforce on the whole would be workers. So I will go through the options on the basis it would have been applying to a worker. So that's somebody who is employed by you in the UK. So EEA nationals do not have to apply for a registration certificate to prove their status as exercising a treaty right and right to live and work in the UK, but it would be prudent for them to apply for one now, as it may assist with any transitional arrangements. So if they've got less than 5 years residence, but may not qualify for permanent residence, which requires at least 5 years residence in the UK, the certificate will be endorsed on a passport or on a separate card, and it will show that they're free to work and live in the UK during the validity of that document. And again, I'll repeat, it is totally optional at this stage, but it is wise for people to apply for it now. The cost is minimal at £65. However, the application process is rather tedious in that it could take 6 months, and a good proportion of that time would mean the individual would be grounded in the UK. The second option, which is for those that have been living in the UK and exercising treaty rights here for at least 5 years, they would have automatically deemed to acquire permanent residency on their 50th year anniversary of exercising those treaty rights, and therefore free from UK immigration restrictions. Anybody in that category are strongly advised to apply for that now. Applications are already on the up, and processing times are now being stretched and may well exceed the 6 months that we're allowed under EU regulations. And by having that status, they will have the reassurance that in spite of any transitional arrangements, they will be able to continue to live and work in the UK. Now, applying for permanent residence is now a prerequisite to naturalise, so to become a British citizen in the UK. So once they've been living in the UK for at least 6 years, hold permanent residency for at least 12 months, they can apply to naturalise as a British citizen, and that will mean they have a British passport. This needs to be considered carefully, depending on the nationality of the EU national, as a number of EU member states do not allow dual nationality, the Netherlands being one of them. So from a HR global mobility context perspective, what you should be looking at is assessing the number of EEA national workers you currently have in the UK, those that have been here less than 5 years, or those that have been here more than 5 years, so you can group them into the 2 types of applications that they may apply for. The other thing to look at is a potential loss of a particular labour pool and how you will be able to fill that moving forward. We can just move on to the next slide. So what next? We don't believe there's going to be a mass repatriation policy, even though the PM and the Brexit ministers aren't committing to the rights of EEA nationals currently in the UK. This is clearly a negotiating point and will be confirmed at the last possible minute. So we expect transitional arrangements to be put into place to regularise the status. This is likely to mean an application to show an EEA national is applying one of the treaty rights to their stays in the UK, so a qualified person to continue their stay. The alternative is that they're pushed to apply under the current points-based system, which is far stricter than EU regulations. We can expect restrictions to further EEA immigration if it looks like the floodgates are opening and we're seeing mass immigration from the EEA before any restrictions come into place. The current points-based system will need to be reviewed to cater for the increased demand in sponsorship and for skilled workers in the UK. Now, the current system only caters for highly skilled roles in the UK. It requires you to have a sponsorship certificate. It doesn't cater for low-skilled migrants. Particularly, this is where we might see a big impact, where post-Brexit we don't have access to as big a pool for labour, and certainly if we haven't upskilled homegrown talent, we could see a huge gap there. We could just go to the next page. Now, this last slide, I just wanted to refresh and remind and inform people what the current system looks like for immigration outside of the EU regs. We have a points-based system. The Brexit camp are always asking for a points-based system, but we've had one in place since 2008. So we could only assume this means rejigging the current system. So it's a 5-tier system. Tier 1 is for your highly skilled workers, your investors, your entrepreneurs. Tier 2 is for skilled workers with a job offer, and it requires the employer to hold a sponsor license. So for those of you on the phone that don't have a sponsor license now, you may wish to look into applying for one or have one on the cards, as this may be one of the requirements and part of the transitional arrangements for you to continue to employ EEA nationals in the UK. So Tier 3 is for low-skilled labour, which has never come into force, so we've never used it. We could see this open up under the points-based system to allow employers to bring in staff that wouldn't qualify under Tier 2. We continue to have our Tier 4, which is our students, and our Tier 5, which are our temporary workers and youth mobility. So the Tier 4s and 5s may then be opened up to EEA nationals looking to study in the UK or having a cultural exchange program which would allow them to stay and work in the UK too. So there will be a lot of change we're expecting. So again, short to medium impact is limited. It's business as normal, but it is worthwhile preparing for significant immigration change and reform. How restrictive it will be, we just don't know at this time. Thank you. And the next slide, please. And back to Paul.
Thank you, Sapinder. I'm going to trot through some domestic law impacts and some international agreement impacts before handing over to Carl. Next slide, please. The principal purpose of this slide is to explain how EU law is implemented in the UK and what might happen therefore. So the European Communities Act was the act by which we acceded to the Union, and the European Union Act was the act setting up the referendum. Just worth noting that that act did not bind the result of the referendum, although obviously we have the sort of moral imperative, and the Brexit means Brexit, that the government has followed. So it seems that the decision of the referendum will be followed. The other point to mention, just on sort of picking up that theme and the Article 50 theme that we talked about in my last session, is that there is quite a bit of academic debate about whether an Article 50 notice could also be withdrawn once it's been served. And I think today in the FT, Lord Kerr, one of the diplomats involved in drafting Article 50, who acknowledges it was a bit of a back of a fag packet job that perhaps wasn't as thought through as it might have been, recognises that because the directive does not say that it can't be withdrawn, he would say it can be withdrawn. And there is some substantial opinions of two leading QCs to the House of Lords that says the same. European jurisprudence differs on that point, but it is an interesting academic debate. I think while some people might see that as a route to a negotiating tactic, others just see it as presenting more uncertainty at a time when actually certainty is what is craved. But generally, the point of this slide, as I say, is to show that European directives are often implemented either through primary legislation, so full-on acts of Parliament, or secondary legislation, orders or statutory instruments. And so actually, by leaving the EU, the directives don't just disappear where they've been implemented in those ways. They're still on the statute book. So there's still binding legislation in the UK that exists, that implements EU legislation. Now, there may be bits of it that don't quite work, and in my sphere, there are probably more than many other areas. So, for example, where in financial services legislation, a directive says you're able to do this provided you are a EU credit institution, what then happens to the UK implementing legislation? It makes it a bit more difficult. So there's a substantial legislative exercise in fixing some of those points. Next slide, please. I think it is worth remembering that there are domestic law, there are obligations under the Communities Act to settle outstanding EU bills. So any sense that exit means those things fading away is not true. In terms of corporate rights, the point here is the one I made earlier about the rights for UK and EU companies with cross-border affiliates. So this is the passporting under financial services that particularly the City of London is concerned about. The classic case of one of my American partners giving me a call and saying we've got this great US institution wants to set up in the UK as the base for its passporting of financial services across Europe. I think great. Now I think fingers crossed that we sort out the passporting system. The UK legislation implementing passporting simply follows the EU directives which provide for it. So it would be null and void if passporting did not continue. Complexity of regulations and directives. Well, as I say, most of the EU legislation is implemented through legislation here. There are some what are known as directly effective pieces of European legislation which don't require implementation themselves. They are directly effective. And it's possible that the UK might just say, well, let's carry on with them then. And again, in financial services, that is an outcome that many here would not be too concerned about. So a neat solution of gaining equivalence in a post-Brexit UK-EU relationship would be to adopt some of those directly effective pieces of legislation and be equivalent. Next slide, please. Sapinder's already touched on the working rights and the trade-off there. And on immigration, so I won't spend any further time on that slide. Let's do the next one. Thanks. International agreements entered into by the EU. So the point of this slide is to point out that there are some major international agreements to which the UK benefits or is a party by virtue of being an EU. So if it's not an EU, it's no longer a party to these agreements. Now, again, let's be clear, we're not saying that the potential final outcome of those might not be that we end up with similar agreements, but as Aline mentioned, negotiating these sorts of things takes a considerable amount of time. Next slide, please. Future contracts. So many people have said to us, what do we do with our contracts? Do we need to trawl through all of them right now and fix this for Brexit? Short answer to that is no, because we still don't know what the post-Brexit looks like. We still don't know what the legal relationship looks like. There are, English law is a very well-established legal regime. The choice of English jurisdiction, UK courts, is well-established, and it's established in that way because of certainty. It's considered a certain regime and a relatively clear regime. There are issues post-Brexit in terms of enforceability and reciprocity. So previously, before the EU, you had to work out how to enforce a judgment in a particular jurisdiction. Post, it is much more straightforward. So worst case, we go back to where it was before, and you go through the pain and agony of trying to work out how to enforce a judgment in another country. Next slide, please. The point here, I suppose I want to pick up for this industry sector is on, say, large financial contracts. So if you've got hedging of interest rates, hedging of FX, some people have said, oh, we need to get right to your ISDA agreement now and check that it's not going to be in event of default and that the counterparty is not going to terminate your agreement and you're going to be left in a terrible position. The short answer to that is, for those sorts of contracts, again, it's very unlikely that there would be a termination event or other equivalent provision that does that. And ISDA itself has come out and said that. So unless you've got a very unusual contract that for those sorts of financial contracts, don't think there's an impact at all at this point in time. Next slide, please. This slide just summarises potential issues that people ought to bear in mind when drafting contracts. And again, you don't have to do this right now, but so some people have said to us, oh, if there is a Brexit, do I need a termination right? Well, you might not. You might take a view that you want to carry on trading, but you might look at increased cost clauses. You might look at frustration of the contract. Different jurisdictions have different concepts. Germany has a concept which is quite similar to our material adverse change, where our German lawyers tell us that it is possible that a German lawyer could come to the view that the contract was capable of being terminated just as a result of a Brexit. We find that a bit odd. We think English law is rather more flexible in that respect. So on that point, after that canter through, I'll hand over to Carl. You're going to talk about IP.
Thank you very much. My name is Carl Rosler. I lead our IP practice here in London, and I'm going to be talking about the changes that will take place as a result of a Brexit on intellectual property. Now, there was not much said during the campaign on either the Remain or the Leave side about intellectual property, and perhaps it's not really a huge vote winner or something that struck a particular chord in the way that immigration did. But I think that's rather a shame, because actually for people in your position running businesses which have to innovate, which have to protect their rights, which have their reputations to think about, intellectual property forms an extremely important part of your asset base, and it's an extremely important part of your consideration. And actually the impact on IP of a Brexit decision, whether or not one goes into a Norwegian model or a Swiss model or one of the other models, is really quite significant. To begin with, I'm just going to try to identify different types of IP, and I don't mean that by talking about that, I don't mean copyright and patents and trademarks. We'll come to those in a moment. I'm talking about the different ways that they're legally expressed. So some IP rights are national rights. You can go to the UK Intellectual Property Office and ask for a UK trademark, and that's what you're given. Some other intellectual property rights, many are the subject of harmonisation at a European level. That does not mean that the law in all of the jurisdictions is the same, or that there's a single law, but it does mean that we're subject to a regime where our laws have to contain certain protections and certain rights and certain obligations, and almost all of our intellectual property laws are the subject of some form of harmonisation. And finally, we've got what I will call unitary rights, and that's where there is a single property right which covers the whole of the EU territory. So you have, for example, a European trademark, and that trademark is as valid in France and Germany and Italy and Spain and the UK, just in the same way that the UK trademark is just as valid as in Cornwall as it is in Wales as it is in London. So they are single unitary rights. Now, it's been said by many of the speakers before, the first thing to say about the recent referendum decision is that it doesn't change anything. And it also doesn't have an effect on a number of international arrangements that we have. For example, copyright is handled on an international basis as a result of treaties such as the Universal Copyright Convention and the Berne Convention. Patents are subject to the European patents anyway, subject to the European Patent Convention, and we have the Madrid Protocol in relation to trademarks, which allows you to file trademarks on an international basis. None of those treaties and arrangements and procedures are subject to us being part of the EU, and so they'll continue in force. But there are some big changes, and so let's look at the different types of IP rights. Can we please go on 2 slides, please, if that's okay? The first slide is what I've just been talking about, and now we're going to talk about patents. So, as I've mentioned, there are UK patents. You can apply for a patent to the UK Patent Office and simply get a UK patent that covers only activities in the UK territory. But the more usual route nowadays is to apply for a patent through the European Patent Convention at the European Patent Office in Munich. That gives rise to a single review, a single examination of the patent to see that it complies, that it's inventive, that it's novel, that it complies with the various tests. But at the end of the day, you designate a number of countries that you want that patent to be enforced in. That's to say, I would like my patent to apply in the UK, Germany, Switzerland, France, and some of those are UK, some of those European territories, some of them are non-European, such as Turkey, and you get given at the end of the day a bundle of national rights. And so with patents, the position will not change as a result of the UK coming out of the EU. However, it is worth mentioning one thing, which is the unitary patent. This is an idea which has developed over the last 10 years and was about to come into effect. We were about to have a unitary patent court, which was stationed not far from our offices here in London. And that idea was for a single patent, which would cover the whole of the EU territory. And that now looks as if it is certainly dead as far as the UK is concerned, because we won't be part of the EU. But it also looks as if it may well be significantly delayed in terms of the rest of Europe, because Britain was such an important part of that overall scheme. Let's move on to the next slide and talk about trademarks. Again, we have a national system where you can have a national trademark, but one of the great success stories of the European Union is the European trademark. There are about 1.2 million European trademarks that are currently in force. You make an application to Alicante in Spain, to the European Trademark Office, and you get given a right which covers the whole of the European territory. Now, once the UK is not part of the EU, whether it is part of the EEA or EFTA or anything else, once it's left being a member of the EU, community trademarks, European trademarks, will not apply. That's to say the protection will not apply in the UK. One can see that that gives rise to a very significant potential issue, and we're going to have to think about what we could do about it. Perhaps if we go to the next slide, we can have a think about the sort of options that might apply. We thought about how there may be some kind of conversion or extension of EU trademarks. There are different models. Some, like the little territory of Jersey, have simply said, oh well, EU trademarks will apply in Jersey. That doesn't mean to say that they have any control over which rights are there or who has those rights or whether they're valid or invalid. They just say, well, if it's good enough for the office in Alicante, it's good enough for us. And that's fine if you're a small territory, but I don't think it's the suitable model for the UK. It's much more likely, and historical precedent tends to show, that where you have countries like Yugoslavia and other countries that have broken up or broken away from the EU, you tend to have a model which is a revalidation model, which means that you essentially have a period of time in which you can say, I would like my community trademark to also qualify as a new UK trademark, but I would also like it to enjoy, importantly, the priority date, the original protection date of the EU protection. So that is likely to be a model that is looked at. But it still does not mean you'll end up with two rights. It still does not mean that if you like, that there will be a re-extension of the EU right to cover the UK. And that has an implication in relation to the concept of use. In relation to trademarks, if you do not use a trademark right for a long period, you can actually lose that right. You have normally a 5-year period to show that you're using the trademark rights. And for companies that use their trademarks a lot in the UK, but perhaps not in other EU member states, the question will arise, well, if I'm only using in the UK and the UK is not part of the European Union, does that mean that my European trademarks will start to be vulnerable to be invalidated? And the answer, I think, is yes. So you may want to think about using trademarks on a European basis. And the other thing I think I need to mention is the impact on litigation. One of the things that the EU trademark regulations do is to oblige each member state to appoint one court to be a community court. And that's to say a court which will handle community trademarks. And in our case, it's the High Court in England. Now, once we're outside the EU, the community court, there will be no community court. We will have no power to grant pan-European injunctions or to make any decisions at all about European trademarks. And that may well have a big impact on the way that people deal with their litigation when they're looking at European enforcement matters. Let's go on to the next slide, please. Designs, the things that protect the size, shape, configuration, the design of bottles and package shapes and all sorts of industrial designs. These again are the subject of unitary rights in the form of the registered community design, which is essentially similar to an EU trademark, but it protects a design. And there's also a UK designs regime. So I'm not going to say very much more apart from to repeat my remarks in relation to EU trademarks. After Brexit, we will not be part of the EU, and therefore the community design will not apply in the UK. Equally, we will not have a court which can make decisions in relation to registered designs, EU registered designs. Let's move on to the next slide. I can talk a little bit about copyright and database right. You will remember that I said at the beginning of this presentation that some rights are the subject of harmonization, but are not, if you like, unitary rights. Well, copyright and design right, and database rights, the rights to protect literary works, artistic works, books, plays, films, graphical works, and computer software. These are subject to national laws which are to some extent harmonized. And as a result of that, there will not be any change to those rules because the statutes are national statutes. There are a number of directives that the EU has implemented and that we have implemented into our legislation, which deal with things like digital copyright and music streaming and internet, and those will stay on the statute books to the extent they've been implemented into UK legislation, unless and until a future UK government decides to abandon them or to change them, or indeed in case the EU enacts further legislation which we choose not to follow because we're not part of the EU. So at the moment, if you like, it's like a group of boats that are all tethered together. They can bob about a bit, but they're all effectively in about the same place. And what we're going to see is that the ropes that tie them together, as far as the UK is concerned, are going to be cut, and the boat may stay in the same place, but over time the boats may start to drift apart. So let's move on to, I think, the last couple of slides and just talk about things to think about. The first thing I think I'm going to mention is just filing strategy for trademarks. Nothing to do just at the moment, but let's think about whether we need to be filing UK trademarks as well as EU trademarks, or whether we're going to rely on revalidation as and when that's negotiated. I do think it's important to echo some of the things that Paul was saying about agreements, and there are a lot of IP agreements out there, or agreements involving IP, whether they're licenses or coexistence agreements or agency agreements, distribution agreements, lots of commercial agreements that involve IP. And you've really got to look not at the commercial terms, although those are always important. You have to start looking at what we call the boilerplate, the things that you hardly ever look at. Because suddenly a definition of territory where you're licensing someone a trademark in the EU, you have to decide whether you meant in the EU from time to time or in the EU as it was when the contract was entered into, and how those are going to be dealt with. There may be even issues as regards the definition of the United Kingdom, given what Scotland is saying about having a second referendum itself. We also should be thinking about proper law clauses. Let's think about exclusive jurisdiction clauses in circumstances where the English court is no longer able to deal with all of the rights or to make decisions in relation to some aspects of the rights. And we may also want to think about pricing and termination in a world where in an intra-European contract we weren't expecting there to be any tariffs, but then tariffs are imposed and we have to decide which party that will fall on. These are all things that I think we need to be thinking about now, because most of the agreements we entered into will be sort of between 3 and 5 years in duration, and that means that they're going to straddle the period where Brexit will be taking place. So I think that's all I probably want to say on IP. It's a very important topic, as I hope I've managed to convey. There's a lot of things we do know. If people have questions, we're happy to take them, and I think that probably takes us to the end of the formal presentations today. Sorry, we've overrun by a little. But if people have questions, we're happy to take them now.
Great. Well, I think, can I start by thanking all the speakers for their presentations. We do have some questions that have come in from attendees on today's webinar. I think the first thing that I'd like to say is that we will be putting the slides on our websites and sending them out. So if there's any point that you've seen that you want to go back and check, the slides will be available. And if you do have any specific more questions for any of our clearly expert speakers, then I'm sure they'd be happy to answer your questions and please feel free to email me and I will get in contact with Squire Patton Boggs, or I'm sure you can go directly. The first question came from, bear with me, one of our speakers is Kevin Jackson. I think this is probably one for Supinder. Of the 3 million EEA nationals living in the UK, is it known how many are registered as working?
No. It's a mix of all the various treaty rights, and the NI records that came out a few months ago kind of weren't in sync with the official records of migration. So it's estimated at 3 million. We don't know how many of those are workers, because I don't think we can rely on the NI records.
Okay. One of our other questions is, did you mention anything about CE marking? Is there anything on CE marking that that you guys can add at all?
Yes, sorry, it's Eileen from the trade perspective. CE marking is obviously, I mean, highly debated at this stage. It's very difficult to foresee the impact on CE marking, because the reality is that you CE mark the product in order to demonstrate that you comply with the regulatory standards that apply to that product. And to what extent we assume that those standards will, the ones that are already in existence now in the EU, will remain part of the domestic legislation in the UK. However, having said that, it's possible that there would be changes. To what extent there would be some sort of impact on how you place your products on the EU market and in the UK market, it's still to be seen. But obviously, anything that will remain to be placed on the EU single market will remain under the CE marking requirements, and that will not change. That includes at this stage products that are placed in the EU and the EEA. So if the UK chooses the EEA model, CE marking rules do not change. If it goes for a model that is not this one, potentially there will be some sort of either additional standards or mutual recognition of the standards so that products could be CE marked.
Okay, and thank you for that. The next question we have is, we hear much about access to single market, but under what new relationship model would the UK still be able to have an input in the formulation of rules and regulations? For example, chemical legislation. Under what rules would we have any input under the formulation of the rules and regulations?
I think you have to break down a number of considerations to answer that question correctly, I think. The reality is that access to the single market will be exactly as determined by the trading relationship that the UK will choose.
Sure.
If, for instance, remains part of the EEA, which is the most integrated model, access to the single market will majorly be preserved. Then you mentioned chemicals and other sectors. The reality is a number of the rules that apply with trading in those sectors are determined by an additional membership to international arrangements. And the UK will remain a member in their own rights in a number of those international arrangements. So to some extent, these questions will depend on the answer to give to this question depend on which sectors we are looking at. Yeah. With respect to chemicals, as I said, there are a number of internal arrangements in which the standards are being discussed and agreed upon, and assume that the UK will still remain a member of that.
Okay.
But I suppose the point to make at the end of that is, if and to the extent that the rules are decided at an EU level, then the answer to the question is none of the models that we have discussed, whether it be EEA or Swiss model or a World Trade Organization model, none of those models allow you a seat at the table to vote on those rules, if and to the extent that those rules are determined at an EU member level, which is no more than common sense.
Okay. The next question, which I think is that we got one or two for Supinder now. Has there been any indication that the 5-year period for permanent residence will be changed or extended. Has there been any suggestion of any changes to those rules at all?
No.
No.
Well, nothing's been pitched at the moment on how the current rules will change.
Okay.
As it stands, if an applicant has been in the UK for 5 years exercising one of those treaty rights, they're automatically deemed a permanent resident.
Right.
They don't have to apply for a card, but our advice is they should.
And can you tell me how much a sponsor's license is? Does it depend on the size of the organisation?
Yes, it will depend on the size. So if you're a small organisation, as defined by Companies House, it's just under £500. A medium to large size organisation, it's just under £1,500. And if it's a charity, there is a discount, and I can't remember the exact fee offhand.
Okay. And then one question for Carl. You mentioned the revalidation model. Is there any indication how large a period of time there would be for the revalidation model? Or is this really depends on what the rules that come in are?
No, there's no indication. We're speculating at the moment. There's not even any indication that a revalidation model is being considered.
Yeah.
As I said, IP is one of those items that it will rapidly go up the agenda, I think, but at the moment it's not had very much place at the table. I mean, to give some idea, one of the models that was looked at was the thing that happened in 1921, I think, when Ireland stopped being part of the United Kingdom, and Ireland set up its own trademark office, and there was a revalidation of UK trademarks to form separate Irish trademarks. Well, there I think that the Irish trademark registry was set up in 1927, so it took 6 years after the fact for the institution to be set up, still less to have the revalidation. But I don't think that we will be looking at a period as long as that. But I do think that actually there is likely to be a period of, I mean, one of the ways of doing it is to say that the revalidation continues until the next time for the renewal of the trademark, which would be on a 10-year cycle. It's difficult to say, but I think it will be measured in years rather than in months. But as I say, there's really we've got no indication or no basis for saying, picking any particular figure at the moment, because that has not even been, if you like, approved as a concept of these things.
Thank you very much. We've got a couple more questions. Aline, I'm afraid they're mostly aimed at you. You said being in the custom union, forgive me, e.g. Turkey, is the least likely option, but isn't this the only one without free movement?
Sorry, is it the only one without free movement?
Without free movement. So is the model that Turkey is currently under, is that the only one of the 4 models that you mentioned that doesn't necessitate free movement of EU nationals?
It's not the only one, because, for instance, if you're a WTO member, which is the last option that is discussed, there is no freedom of movement. But yes, I mean, if you look at Norway and EFTA, they have to abide by freedom of movement.
Okay.
But as we said, it's there is also, which something perhaps I have not really mentioned in details because it's still very hypothetical, but the potential of crafting a bespoke arrangement, and that will be up to the UK government to come up with specific proposals.
Now that actually you've anticipated the next question that we had, which is what's the chance of us coming up with a new relationship model? So do you think, in your opinion, that is the road the UK will go down, that it will create its own bespoke relationship model, because it is a much larger country and economy than Norway and Switzerland? Do you feel that a bespoke option is the one that we will end up with?
Well, I'm going to start answering that, but perhaps also leave other speakers to input. I think you have 2 answers here. The first one is what the government line will be, and at this stage there is no official statement as to whatever options will be focused. Why is this? Is because as Paul mentioned at the introduction of the presentation, the priority is the Article 50 and the withdrawal agreement, which which will concentrate in the first stage the effort of the negotiations, how the UK will withdraw, and that withdrawal arrangements will touch on the most immediate priorities on the terms on which the UK will exit the EU. With respect to your point on negotiating the future trading relationship, we've heard originally, I think, more potentially pros in favor of the EEA option, but which, and that's my personal comment on that, I don't see how politically it is realistic, because accepting freedom of movement would completely undermine the whole objective of the Leave campaign, which in effect won on the 24th of June. That's my personal comment on this one. The reality is, yes, I mean, the UK is not Norway, the UK is not Switzerland, and of course the way it will enter the negotiations will be different. There are two, I think, priorities that the UK government will obviously have to take, and is taking at the moment. In order to enter into a bespoke agreement negotiations, it needs to know exactly what it will ask for, and to know what it has to ask for, as we've seen, it's a highly complex sort of assessment that has to be made. Hence the reason why the new Prime Minister has set up this new ministry, international trade, looking at hiring hundreds of negotiators. And I think there will be a lot of creative thinkers, hopefully, in that team, and a lot of very experts in each of the areas that we touched on that will form part of negotiations, that could potentially form creative options. Then trading negotiation is a trade-off, and when I was sitting and observing WTO negotiations in the grid rooms, whatever you propose, you also have to take away and to concede at some stage. So I think it's really important for federations, just like yourself, to also be part of this exercise, because there is potential to ask and to be granted potentially new rights that perhaps was not possible of the EU membership. To what extent it will involve trading off, that's the big question mark. But yes, a bespoke arrangement, and the UK is a different economy, so there is room for manoeuvre.
Can I just add one thing, which is to say, I mean, I think I agree with Aline that there will no doubt these models that we've discussed may inform people about the spectrum of different choices, but it seems to me that it's unlikely that any one of those models is a particularly good fit for something that's UK shaped. But one thing I think that we need to just focus on, and I don't want to sound like a merchant of doom and gloom, but there's an article that no one really talks about, which is Article 218 of the Lisbon Treaty. People talk about Article 50 as if it's the only part of the treaty that matters. Article 218 is the article by which any third country, any non-EU member state, has the right to, or the ability to, form a trading arrangement with the EU. So, for example, if Turkey wanted to become a member of the EU, then it would apply under Article 218 to be a member. And Canada, which is in the middle of trade negotiations with the EU and has been for the last 9 years, it makes its application under Article 218. The crucial thing, the crucial distinction between Article 50 and Article 218 is that when you are leaving the EU, you leave on the basis of an agreement which is approved by qualified majority. That's a situation where each member state has a number of votes based on economic power and other factors, and a qualified majority will get you out. But when you wish to enter into a trading agreement of any sort, membership or something lesser with the EU, you have to get unanimous approval of all of the member states. And so that means that you're going to need to get 27 people to say that they accept that deal. And I think that one of the factors that's perhaps the scariest for me is that you know, any member state, be it Malta or Poland or Bulgaria, any member state can effectively veto not just our re-entry into the EU, but any deal that we want to do with the EU. And the reason that they might take such a stance is they might say, well, we don't mind accepting an agreement like that, but this is our opportunity to air our grievances and to get a better deal or a different deal for ourselves. So the problem is it's not just a bilateral discussion between the EU and the UK. It ends up turning into a situation where everybody has their own agenda, and that's what's made these trade agreements with between non-members and members so very, very complicated.
Fantastic. I think with that final question, we'll conclude this edition in the BPF webinar. I'd like to take this opportunity to once again thank Aline, Supenda, Paul and Carl. And I'd also like to remind all attendees that this is the first in a series of seminars exploring the implications of Brexit. Our next webinar will take place on the 4th of August and will be on topic of Brexit leaving the EU, the implications for exporters. This webinar, and for more information on this webinar, please go to the BPF website or alternatively email events@bpf.co.uk. So once again, thank you to the guys from Squire Patton Boggs, and thank you for listening, and goodbye.